Hi class, my name's Amy McCurdy, and for the past few months I have focused my case study assignments around the Stanley trial and Colten Boushie's murder. This was a case that dealt with many pressing Aboriginal issues such as jury selection, discrimination, interpretations of land cession, the effects of colonialism, and more. Recently in our modules, we saw an expert panel at Queen's discussing the facts of this case, so many of you are likely familiar with the story. However, I'm still going to have to give a brief overview of the facts just to jog your memories. So on August 9th, 2016, Colten Boushie and four of his friends were returning home from an evening of swimming and drinking before the SUV they were driving got a flat tire. Eventually, they went to the Stanley farm in search with help. At this point, the record suggests that somehow an ATV was started, and that Gerald Stanley and his son, Sheldon, confronted the SUV. Sheldon smashed the windshield with a hammer, which is when the SUV then drove forward and hit one of Stanley's parked cars. Two of the passengers fled, and Boushie climbed into the driver's seat. Gerald Stanley retrieved a semi-automatic pistol from his shed and fired two warning shots into the air. He testified at trial that after making those warning shots, he claimed he couldn't see his wife and somehow thought that she was under the SUV. So he ran over to turn the ignition off, and allegedly there was a hang fire, and it shot Colten Boushie in the back of the head. His defense was it just went off, he didn't mean to do it, and Stanley was acquitted by an all-white 12-person jury in 2018. So these are the most basic details of the case, and if you haven't already, I urge you to watch the expert panel at Queen's discuss the trial in more detail. However, we can already see that this case is touching on a lot of pressing Indigenous issues. Coincidentally, August 9th is actually my birthday, which gives me the ability to look back and remember exactly what I was doing on that day and at that exact time to compare to Colten Boushie's situation. So I was on exchange in Italy, and by 5 p.m. Eastern Time, when Boushie was arriving on the farm, I have a recorded video of my friends singing happy birthday to me and the rest of the night market joining in Rome. So to me, this was such a positive memory, and I look back at it often, but it happens to overlap with Colten Boushie's final moments. This is this really represents to me the two different worlds that Canada embodies: the lives of those who benefited from colonialism and those who were colonized under Canada's legal system and legal regime. I now take this time to ask the class, do you think that Gerald Stanley would have reacted the same way if you, or a white person, had entered his farm with a flat tire? Do you think that the jury would have reached the same verdict if Stanley shot a white person? Think about this as I explore this topic more. So beyond the racism evident in Stanley's actions, in my opinion and in the opinion of many others, this extended also to the way in which the jury was assembled. Jury selection is a big topic in this case, and I'm going to be paying a lot of attention to it because it is likely the lack of real, lived Indigenous experiences in the jury that led to what many believe is a biased result and a lack of justice for Colten. It is very likely that many of the jurors shared the same underlying biases, prejudice, and fear of Indigenous people that Stanley did, as it is a huge part of the history of Battleford. I will address that history in a bit, but I'm first going to explore the concept of this jury selection process, in this case specifically. So here I included a picture of Justice Minister Jody Wilson-Raybould, who after this case spoke up for a new selection process. North Battleford has one of the highest populations of Aboriginal people in Canada. So why were there no Aboriginal jurors? Before the verdict, Boushie's family said that the Indigenous-looking jury candidates were challenged and excluded by Stanley's defense team. The jury selection process they are referring to is called a preemptory challenge, which allows lawyers to exclude, without reason, potential jurors. So, why were there no Aboriginal jurors? This is the slide that's going to tie in together jury selection, this case, and the history of colonialism in Canada's legal system all together. So, I'd like to go through those right now. So, preemptory challenges, as we've just briefly discussed, means that defense lawyers and Crown prosecutors may exclude people from a jury without giving any reason, possibly leading to a jury that is biased or a jury that lacks understanding of Indigenous cultural and social customs. So financial, family, and social barriers could just mean some are too poor to afford commuting or taking off work for jury duty, or even something like who will watch the kids. Indigenous people often still suffer from the crippling effects of Canada's colonial legacy, and one of those effects is broken families and poverty. Homelessness, which also stems from the history of colonialism, just means that many Aboriginal people do not have addresses and cannot qualify for jury duty because you need to have an address to do so. The lack of education discourages Aboriginal people from attending because the language is often very complicated. Indigenous people are more likely to be less educated according to our Western school structure because of the lack of support, finance, and more stemming from our colonial history. Also, criminal history. Aboriginal people make up roughly 4% of the population and over 25% of the jail population. There are rules that automatically disqualify Indigenous people with criminal records for minor offenses from jury service. So, and the final is some do not trust or want to be part of a system that works against their people. So, I'd like to highlight how Colten Boushie's family addressed the situation of the biased jury selection. Boushie's family went to the Special Rapporteur on the Rights of Indigenous People, which is a part of the United Nations Declaration on the Rights of Indigenous People, and spoke to raise awareness specifically on the issue of jury selection. So, if anything, this is a testimony to how important even the family believes that the jury selection was in the outcome and injustices that. So I found it a little bit difficult to find exactly what violations they were addressing specifically in the United Nations Declaration on the Rights of Indigenous People. So I went through it myself, and I thought that Article 2 and then Article 7.1 in the United Nations Declaration of Indigenous Peoples was definitely an issue that would be highly related to Boushie's case. So I invite you to pause here and think about whether or not you agree with this, and if there's other articles you think would also be in violation. So just to tie the situation with Stanley's jury back to the Canadian legal system, I prepared a short comparison. As we know, Canada initially opposed the United Nations Declaration on the Rights of Indigenous People. However, their support of the rights listed in this declaration aren't legally binding laws in Canada when they eventually did agree with it and support it. But it's international law, so it's very important and very public, but it is not legally binding. Canada does not have to do it. To me, it is clear that rights were violated in international law in this trial, from the discrimination Boushie faced when he stepped on that farm, and the way in which Stanley's lawyers conducted preemptory challenges made against Indigenous-looking jurors. Whereas in Canadian law, Canada defines Aboriginal rights much differently. The courts decided that an Aboriginal right must be a practice, custom, or tradition which is integral to the distinctive culture of the Aboriginal people involved. Also, that such a practice must be traceable to pre-contact period. Aboriginal rights also include treaty rights, which is in the Constitution, and all-inclusive anti-discrimination laws in the Constitution, Section 15, that you and I both, me as a white person also am protected under. So if they are going to challenge the way the trial went, they'd have to argue that their charter rights were violated in the discrimination against Indigenous-looking jurors. However, there is no Aboriginal rights in Canadian law that I can find that were violated. An analysis of this case would not be complete without an understanding of the land and history of Battleford. So the poor socioeconomic conditions of Aboriginal people in North Battleford, like Boushie, are a result of the historical legacy of colonialism, in part. So often, Aboriginal peoples are blamed for the conditions they live in, but that is not the case. This all began with the destruction and displacement of the traditional lands in 1870 after the settlers killed the buffalo, which led to the signing of Treaty 6. So the next slides listed our timeline, which I used to illustrate the colonial history of Battleford in the context of Aboriginal law, all the way to the death of Colten Boushie. Alright, essentially European settlers killed off all the buffalo and forced the Cree to sign into treaties that were seldom honored. This was a tool used by the Canadian government to displace Indigenous people from their resourceful lands. Boushie's reserve is actually named Red Pheasant Reserve after the chief's brother who signed Treaty 6. I invite you to read some of the quotes for further context. In 1883, they built a residential school, which pioneered Battleford's history of cultural genocide. And in 1885, Cree warriors rebelled against the government, and 8 Cree warriors were hanged. They had no representation and no translations in their trial. This is the largest mass execution perpetrated by the Government of Canada in our history. Here, a woman in the community is quoted saying that the Battlefords have been polarized since this pivotal event took place. I invite you all to return your attention to 1883. I put a quote here about how Indigenous children were taken out of school to watch this event take place, if that makes anything worse. The 1960s began the infamous 60s scoop, where children were removed from their Indigenous homes to further deteriorate the already struggling communities. Here is a quote from a woman who grew up outside of Battleford. This exhibits further how the Canadian government attempted to destroy Indigenous cultures and morale. So since 2015, Battleford has actually been rated one of the most dangerous places to live in Canada. I feel like this quote really summarizes what this timeline is attempting to convey here. From hangings to residential schools, right up to the issue of Indigenous women, this has left an enormous guilt and distrust between communities. Growing up, I was taught to be fearful of white people, our authorities. They were the ones who took us away. This statement, in conjunction to the higher poverty rates, lower education rates, and higher crime rates amongst Battleford's Indigenous population, leads us now to analysis of Colten Boushie's murder. In an environment where it's whites against Indigenous people or police versus Indigenous people, it can really map out the mindset that Stanley had towards Boushie on the night of his murder. He saw him as a potential danger because he was Indigenous, without understanding the colonial legacy and that contributed to the high rates of crime and poverty in the Battleford area. So now I just want to quickly rewind a bit to the treaty that started this all, Treaty 6. So Colten Boushie was historically a part of the Plain Cree of Saskatchewan, which believed humans are intimately linked with the world around them. One of the Cree values, the key values of the Cree was sharing, and hunt was shared as well as other resources. And another key concept was the Wakotowin, which means kinship, if I pronounce that right. And it's important not only for the human relationships, but also in terms of people's connection to the land. So the key takeaway here is the Cree did not believe the land is owned. They believed that resources and land is shared. So in the 1960s and 80s, a series of investigative reports that outlined elders' views on what Treaty 6 entailed and on the concept of land cession found that both organizations concluded that Indigenous seniorities believed that they were agreeing to share the land and its resources rather than to completely surrender it to the federal government. Linguistic and cultural differences likely resulted in a misrepresentation of treaty terms. So to tie this back to the Colten Boushie case, I've highlighted a real quote from a farmer in Saskatoon. I'll read it for you now. The Stanley Farm, just like my home in Saskatoon, is located on Treaty 6 land. So while in one sense we lay claim to the land we live on as our own private property, there's also a very real sense in which our homes are only our homes by virtue of the treaty agreements made between Canadian people and the First Nations people. And so with the share the land interpretation, what that means to me is there wasn't a real sense of, because a lot of what Stanley argued was this idea of trespassing, protecting himself. There was a danger that he was on that land. And in reality, the Cree and the people under Treaty 6 actually historically did not have that interpretation, and they believed that there would be no such thing as trespassing as the land there would be shared. So again, these linguistic and cultural differences really disadvantaged the Indigenous people who were colonized on this land. So on one final note, just to tie everything together and back to Aboriginal law and the Canadian legal system, I highlighted some key issues that this case represented. So The history of colonialism clearly set the tone for the discrimination of Indigenous people faced historically and today. I'm not so sure Stanley would have been murdered if a white man looking for a spare tire on the night of August 9th showed up on his farm. Um, and even if he did, I'm fairly certain the jury would not have acquitted him completely. This discrimination and racism stems from even before Treaty 6 was ever signed. Still the treaty that today still benefits the families of settlers which reside there today and call that land private property. This also highlighted the reluctance, even today, for the Canadian government to reverse and heal the effects of colonialism as much as possible in our justice system. As we can see under international law, the jury on Stanley's trial would have been a violation of the rights found in Article 2. However, no such right exists in Canadian law, except under all-inclusive anti-discrimination laws found in our Charter. So this concludes my presentation. I hope you enjoyed it and you learned something, and I thank you all for listening. I did ask some questions throughout it, and if you want to respond to one of those questions in a comment, that'd be greatly appreciated, and I would be more than happy to respond and have a dialogue. So thank you.